Good afternoon. My name is Ward Keever. I am the founder and CEO of Covenant Wealth Strategies. Today is Wednesday, March 27th. I'm joined by our own Michelle Fisher, and we will make introductions to our other illustrious guests here momentarily. We are going to be discussing today how to help families successfully transfer wealth. And this is something that we are very excited to bring to you. We have been focused for quite some time on multi-generational wealth planning. And wealth is an important word because it's not just per se money. Wealth encompasses a broad range of things such as values, in addition to money. So we're going to be talking today with our guest, Emily Dupree, about helping families successfully transfer wealth. We are joined today by Brian Marks, who is our relationship manager with MFS. Brian and his wife, Katie, and their three elementary school children live just outside of Baltimore, about 30 minutes away from the Key Bridge situation. We're certainly keeping all of those that are involved in that circumstance in our thoughts and prayers. And presenting today will be Emily Dupree. She and her husband Patrick live in southern Maine near York Beach. And we were just talking about all the snow that they got just north of them, 2.5 feet. So they spent this past weekend skiing fresh powder in Maine. So that's exciting. Emily is a managing director at MFS Fund Distributors, and in this role is responsible for delivering practice management solutions for financial advisors with specific tools on specific focus on generational wealth conversations and Social Security planning. She manages a team of relationship managers in the Mid-Atlantic region. Emily joined MFS in 2004, so 20 years ago. I know she started when she was 12 with MFS, and she became a field representative in 2007 and assumed her current role in 2021. She actually started with MFS right out of school after working, I think Emily had said, part-time during school with MFS. She has a bachelor's degree from Northeast University and 2 boys ages 12 and 10. I like to learn a little bit more than just what's on the printed bio. And so I learned that Emily enjoys women's rugby. I think that's the first time I've ever said that about anybody that I know. So not only does she enjoy it, she plays women's rugby, right? And she also, as part of her upbringing in southern Maine, did some work around the Bush compound and actually served George Bush Sr. lobster at the Bush compound. So those are 2 things I have never said about anybody else that I have met. So Emily, I'm just fascinated by those 2 things, and we are looking forward very, very much to your presentation. So without further ado, Emily Dupree, please take it away.
Thank you, Ward. Thank you, Michelle. Good evening, everybody. As Ward mentioned, my name is Emily, and I love talking about the topic of wealth transfer. And one of the biggest reasons why I like it so much is it's something that's going to impact all of us. So just to set the perspective before I bring my slides up is, if you think about it, if your parents are still alive today, you're going to be the recipient of a wealth transfer. If you've got children or named beneficiaries, you're going to be part of passing a wealth transfer. And if you're like myself and like Brian, which Ward just talked about, is we still have parents, we've got children. They call us the sandwich generation. We're going to go through 2 wealth transfers. So it's so important to delve into the topic as I bring my slides up now, because unfortunately, the majority of wealth transfers in the United States fail. And that is not what we ever want to have happen to you and your family. So as I go through the presentation today, you might have a lot of questions come up. So on the screen, what you'll see here is Michelle's email address. If you've got a question you want to ask, and I'll bring this back up at the end, just send an email on to her and we'll hit that at the end of the topic. I do want to remind you, I am not an attorney, so no direct legal questions, but we're happy to link you with one after the fact if need be. So let's get started. So I mentioned everything's going to fail. I don't want that to happen to you, but I want you to understand what I mean when I say the majority of wealth transfers tend to fail. Second most important is how do we plan to ensure we don't make these common mistakes? And then finally, what are things you can take back to your family to communicate about your lasting legacy? So let's start with fail. What do I mean by that? Well, what we see most commonly happen when wealth transfers are happening is first, Uncle Sam steps in. And if not done correctly, you could be paying more in taxes than you need to. Second, getting caught in the court system. Now, since the pandemic, right, the court system is still rather slow. It's gotten slower. And another difficult part with estate planning is if your loved one passes away in a different state that you live in, you actually have to go to the state they passed in to settle. So a lot of time takes place during wealth transfer. Third, this one I don't like at all, but it happens so much when money get involved, right? It seems like we get along with our friends and family until that money comes into play and we create that family infight. And then last reasons why we see wealth transfers fail is it takes basically 18 to 24 months today for your heirs to spend all of their inheritance in its entirety. Now, as a mother of two boys, I do not want this to happen. I don't want it to happen in my family, and Ward certainly does not want it to happen to any of your families as well. So the best way we can go through this presentation is I'm going to walk you through the 5 biggest reasons why we see wealth transfers fail. So again, you can prevent those mistakes within your own family unit. So let's start with reason number 1. Reason number 1 is not having a plan at all. So less than 50% of people today in the United States have a will, and less than that have a trust. And the 2 biggest reasons we see this is first, people are uncomfortable talking about death. So what I ask is you change that conversation from talking about your death to transitioning a legacy. It's a much more optimistic way about looking at estate planning. The second reason, though, is just confusion. What am I supposed to have? And when people get confused, they tend to be paralyzed and we don't do anything. So I'm going to walk you through the 4 major documents that would make sense for your estate plan. So first is a will. Everybody should have a will. If you don't, do you know who decides your wants and wishes? It's actually the state that you pass away in. So I currently live in the state of Maine. Could you imagine I pass away, I don't have a will, and the state of Maine gets to decide where my money goes? That's not what anybody really wants to have happen. A will in place will prevent that. It gives the state the exact directions of your wants and wishes. The second document is the trust. And I think people get confused by a trust because they feel like, hey, I need a complicated estate or I need a lot of money to have a trust. And that's not generally accurate. The biggest reasons we see people want a trust is first, privacy. So a will is a public document, which essentially means anybody can go down to the court system and pull your will and look at what's in it. If you don't like the idea of that, a trust is a perfect solution. It's a private document and people do not have access to it. It also avoids probate. Second reason for a trust is if you're passing money to somebody that might not be able to handle it on their own. They could have a disability, they could have a history of addiction, or for myself, they just might be too young. And what I mean by that is the legal age to receive assets in the United States independently is 18. Can we all agree on this call that the 18-year-old is legitimately like the new 14-year-old? Right? I couldn't imagine my children at 18 receiving hundreds of thousands of dollars and spending it wisely. So in my family, we actually have a trust in place that if my husband and I are to pass, our children do not have independent access to that money until 30. Other reason for a trust is if you have a blended family. So marriage, divorce, and kids on different sides. The reason this is incredibly important is the way the state law is set up, money usually passes to direct bloodlines first. And oftentimes that might not be exactly how you want the money to pass in a blended scenario. And then finally is direction, right? You might want your children to be charitable. You might want to give yourself money to charity. All of that can be taken care of in that trust format. And again, leaving that legacy, it's such a good vehicle. And then the last 2 documents are your power of attorney documents. And these are incredibly important to have in place before an emergency, because these are the people in your life that can act for you legally when you're unable to do so on your own. Power of attorney for things like finances and investing, and then power of attorney for things like your wants and wishes when it comes to your health. So those four major documents really are what you need to get your estate plan going, and you can work with any attorney and they can set those up for you. Okay, so we're going to have our plan. Reason number 2, wealth transfers fail. We don't share our plan. So oftentimes, if you're a married couple, one person tends to do more than the other. It happens in my family too. I prefer to do the investing. I do the estate planning. My husband just doesn't want to do it. The problem in these scenarios is what happens if I pass away before my husband does? And I'm the one that knew the plan. I had it set up to begin with, but because I didn't share it, right, we're unable to access those documents. The estate might be put on hold, and we may get caught in that court system. So it's incredibly important if you're a married couple to share the plan. My husband and I simply have a folder, and the folder is if I should die. If I should die, here's the location, everything. Here is you should talk about. So when I think about sharing the plan, I think about people and places. Now, the second person besides your next of kin, your loved one, your spouse, your oldest child, whoever that would be, we always say you want to have a backup plan as well. In our industry, we call this the trusted contact. And this is somebody you're absolutely going to want to talk to Ward about, and you probably already have. And the trusted contact and how you figure out who they are is if something were to happen to you or you and your spouse, and you needed to have somebody step in, or we needed to call somebody to see how can we get a hold of you or find out what's wrong, that's that trusted contact. So they're not a power of attorney. They're just a conduit of information in a time of need. So when I think about sharing my plan, I always want to have at least 2 people, one being the closest person, maybe the next to receive the assets, and the second, your trusted contact. Now, next, I also want to talk about places, and I'm going to bring up a piece on the page here. This is a piece we have at MFS called our document locator. So yes, you can tell them you have the plan, but if your loved ones can't find the actual documents, you might not be able to start to settle that estate. This is a great piece that you can fill in and keep in a safe place so your estate can easily be executed. Now, I will tell you, a safe place may not be a safe unless you tell people the password. It may not be a safety deposit bank unless somebody is named to access that. If they're not named, they actually have to go through court. And a safe place is not a coffee can of cash in your backyard unless you plan on leaving a map to your loved ones. So very, very important. Yes, have the plan, but please share your plan as well. Okay, reason number 3, wealth transfers fail. I'm going to spend a bit of time on this one because this is where we see the biggest heartache tend to happen just by simple overlooks. We don't update our plan. So what are the amazing reasons that I would want to call updating your plan? Go put out your documents again. So the first is time. So usually if you talk to an attorney, they'll tell you anywhere between 3 to 5 years makes sense. Just do some double checks. Really, it's if you've seen any change in litigation, and that's something Ward and his team would absolutely talk to you about. If a state law changes or a state tax law changes, that might have you go ahead and look again. Second, if you move. So if you move locations, what I mean by that, so I set my plan up in Virginia. That's where I used to live with my husband and children. Our estate plan, our trust, our will is all based out of Virginia. We've since moved to Maine. The problem is a state law is a state by state basis, and they all treat it just a little bit differently. So if I were to pass away in Maine and my husband goes to settle my estate on documents that are based in Virginia, they might not match up. This could cost him more money. It can cost him more time in the court system. So we actually made sure we went to see an attorney in Maine to take a look at them. And luckily they were very similar, and it didn't cost a lot for us to update just to the main titling type pages. So if you're on this webinar today and you're like, oh my goodness, that's us, please don't wait. It's not very expensive. Just make sure your documents match to your new location. The last are the titling documents. So beneficiary forms are incredibly important to keep up to date. So what are beneficiary forms? So think about your 401k, your IRA, your insurance policy, your investment accounts. When you open up one of those, there's always a beneficiary line. And what that line is there for is if something were to happen to you and you were to pass away, who is the next person within your life that you want to receive those assets? And they're quite convenient because beneficiary lines avoid the court system. They avoid probate, allowing money to easily pass to your next of kin. So primary beneficiary is going to be the first. Where we see the mistakes happen here, and I'll just use myself as an example, is when somebody signs up for their first job a long time ago and they get their very first 401k, they might not be married at that point. I certainly wasn't. So when I went to sign the beneficiary form, I put my sister Sarah on, right? Fast forward 10 years, I married my husband Patrick. I had to manually go in and pull Sarah off and add Patrick on. Could you imagine if I had passed away and left my entire 401k to my sister? Legally, she gets that money. Now, I hope she would pass it over to Patrick, but what a headache and more money that would cost to do something like that. So your primary beneficiary, you always want to make sure it's the first person you truly want to receive those assets. Another area we see with mistakes with primary is with divorce, right? And divorce does happen. The problem is it can create some major controversy. There was a court case. It started in Northern Virginia. The law firm there was the one to take it to the Supreme Court. You had a husband and wife, and they were married for a very brief period of time. They got a divorce. Husband remarried his second spouse, which was his lengthy marriage. When he passed away, second spouse went to settle the estate. And she was named on most things, the will, a lot of the documents, but she wasn't named on everything. What she wasn't named on was an old insurance policy and an old IRA, one that had been taken out years before her. Who was named was the ex-spouse. So she said, well, no, they're divorced. This is all supposed to come to me. So she took it to a law firm who brought the whole issue to the Supreme Court. Who do you think decided in favor of? The ex-spouse. So the reason they do this is they consider beneficiary designations a contract. Whatever is signed there is where the money is going to go because it's a contract. And second, remember I said it's a non-probate asset, takes place outside the court. It doesn't matter what your will says. When you sign someone's name to a document with the designation, that goes directly to them. Finally, the next designation. So primary beneficiary is the first person to receive assets. Many of your documents will also have you fill out what's called a secondary or contingent. So if something were to happen to myself, money goes to my husband, Patrick. What happens if something happens to Patrick? Where does the money go next? So usually most families will put their kids here. I will tell you it's a lot easier to leave your kids off than leave your ex-spouse. So what happens is we just get tired or forgetful or life goes on. I will tell you about my first son, Cullen. So I was super excited to be a mom, and I tried to do all those first-time mom things. If something falls on the floor, I threw it away. I'm signing him up on my contingent forms. He's all signed up. We're good to go. I'm doing great. Well, 18 months later, my second son, Lachlan, is born, and now I have two children under 2. I am exhausted. We evoked the if something falls on the floor, it's a 15-second rule kind of rule and right back in your mouth just to save some time and sanity. And I will tell you, it took me at least 3 years to get Lachlan signed up on every form. And think about all the documents we have today. There are a lot. Now, Brian has 3 kids. Brian, I hope all 3 of your children were signed up. And I also tell you all on this call to think about it. If you come from a family with multiple brothers and sisters, and you're the baby of your family, do you think your parents have you named equally on everything? It is important to check because just like that primary beneficiary, that secondary is law. So if I leave Lachlan off, he technically has no right to the money. What I love about working with Ward and talking to their group is they do annual account registration review for the assets they hold to make sure this doesn't happen to your family. So it's always important to continue to check and make sure you're bringing those documents or any life changes to your team to make sure we are making sure the right names are in place. Okay, so you're going to have your plan. We're sharing our plan. We're going to update our plan. The last one, and this is my most fun to talk about because this is really where you can step in and leave a legacy, but it's also where you can step in and avoid that family infighting that tends to happen to so many people. So being specific with your planning, I like working with the state attorneys because they have really good, thoughtful questions to ask you more than just, hey, where's the money going to go? One of the questions they like to talk about is, what are the sentimental things? What are the things in your life that you believe your loved ones are going to want? This can lead to some massive family infighting. I'm going to tell you a story of my mother-in-law. So my mother-in-law is Patty Doherty. She lives north of Boston, Massachusetts, and she had 7 siblings. Now, her mother was the second to pass away. Her father had passed away when she was younger. So all seven siblings go to the house. And she told me, like, you could really see people sneaking around a little bit, taking things, kind of walking out, and you knew something was going on. And it wasn't feeling right. So they stopped the whole thing and they said, okay, we all want the same things here. Let's just put them on the kitchen table. We're going to draw straws, and that's the order that we're going to pick it. How do you think that meeting went? So there was apparently a Asian tea set that everybody wanted. It was one of those sentimental things reminded them of mom. Patty Doherty has the sugar bowl in her house. I do not know who got the teacups, who got the teapot, but because there was such lack of planning, it caused angst between the siblings. So one idea for you is to map it out. Map out your legacy. What are your wants and wishes? And you can start with the people and then move on to the items. And did you know you can create a map like this or even just a document on paper, sign it and staple it to your will, and that can hold up in court. You can say, yes, I want Patty to get the tea set, and yes, I want Jim to get my belt buckle, and whatever it is that you think your loved ones would want to create a moment of joy as opposed to a moment of controversy. It's so important to do in advance. Now, addition to the sentimental stuff, we do have to talk about some of the money items. And one of them I will tell you that always leads to controversy is any type of vacation home. So let me show you how easy this is to cause a fight. I have two boys, right? Right now, we live in our vacation home in Maine. We moved there during the pandemic. We decided just to stay. So I guess maybe it's not our vacation home anymore. It's our permanent home, but it is at York Beach. So what happens if I pass away and my husband and I, because we think everything should be split equally with the boys, we leave them the home to share? Now, that makes logical sense. It seems like the right thing to do. But what if at that point, Cullen now lives in California and never gets a chance to come back to Maine and Lachlan's using it all the time? Or if one child can afford the upkeep and the taxes and the other can't? Or what if one wants to sell it and the other doesn't? Now, I only have two kids. Could you imagine 3 kids, 4 kids, 5 kids deciding on something that was so loved and great memories is now causing controversy? So this is really important to have dialogue with your adult children if there are items like this that are going to be passed. And you've got to be okay if they say, Mom, the water in Maine is freezing. I don't ever want to go into it again. But maybe one of the kids like, I like it. And then you adjust your will, you adjust what you're passing to your kids. Same is true with collections. Just because you're a collector does not mean your loved ones are. So you want to make sure you're having it appraised and leaving them proper directions for sale. Pets is also a good one. If you own a horse farm and your only living daughter lives in New York City, you're probably going to want to have a plan for them. So all about being specific in advance with your planning really ensures that legacy. Charity. That's one of my favorite things to talk about because when you're passing charity, I love doing it through heavily taxable objects like a 401k or a traditional IRA because you can pass money tax-free, right? And think about leaving that to your children and letting them be the ones to decide or carrying out the wish that you had in advance of where that money goes. That's such a phenomenal thing to do for your loved ones. So I'm going to pivot here and I'm going to talk a little bit about 2 other topics that are very important to be very specific about, and you're going to want to communicate with your loved ones. And these are the harder topics. These are things like what happens when you pass away, or what happens if you have a long-term care scenario. Now, there's a piece that you can get online. This is not an MFS piece. It's not a Covenant Wealth piece. It's called the Family Love Letter. And what I like about it, it's an eloquent way for you to go through some of the more difficult questions, write down your heartfelt answers, and have this conversation with your family. With doing something like this, and I did the cheap version, my cheap version is take a blank piece of paper. On one side, I just wrote, if I should die. So if I should die, what exactly do I want to have happen? I know, my mom wants to be buried. I know my father wants to be cremated. I know my in-laws, Patty and Bernie Doherty, they already have their funeral parts picked out and paid for. There might be certain hymns you want. There might be certain things in the day that you want to have happen. Having that in advance is so important for your loved ones because they're going to have a grieving moment, and making it simple makes something like that so much easier. The other side of my blank piece of paper is a little bit harder. It's if I don't die. And that seems to be a foreign concept to many of us, if I don't die. I think we all think we're born, we go to school, we make a job, we retire, we die. There are chances that one of you, if you're a couple, is going to go through some type of long-term care scenario where you're going to need the help of others. I promise you it is so important to prepare for this before it happens from a money standpoint, but from also an emotional standpoint, because this can be very, very difficult. So Things like, if I'm going to have a long-term care, I'd like to be in my home. Okay, is your home set up for it? What's that going to cost? What's that going to look like? Who's going to be the person giving the care? Or, I'm comfortable with a retirement home. Okay, what is that going to look like? Having these type of wants and wishes decided in advance is so important. And again, it helps that family infighting to stay away, and the focus is really on the loving family. So the last thing I'd like to share, the last reason why wealth transfers fail, is we don't do a very good job preparing our beneficiaries to receive assets. And I will tell you, I am the same. As far as, I don't really like to talk about money with my kids. I cringe a little bit when they say, how much do you make, mom? And how much do you make, dad? Like, we don't say the answer. I don't think we have to tell them the money. We don't have to tell them the number, but I do think it's incredibly important to train your children to be good stewards of money. Teach them the concept of making money, investing early on, being good stewards of that asset, because when they receive more, they're less likely to make a mistake. Introduce them to Ward and his team. Have them have an understanding that you guys are a family meeting team together so they can really get the concept of money. And I did mention in the beginning, you probably heard me say it takes 18 to 24 months for your children to spend their inheritance. I'm just going to walk you through how easy that is so you believe me. So let's pretend I pass away and I've got $100,000 in my IRA. And you can add the zeros of what you're going to be passing to your kids. And Ward calls Colin, my oldest, and says, I'm so sorry, mom's passing. There's $100,000 and you're the beneficiary. Well, what do you think Colin's going to say? 99.9% of beneficiaries will say, send me the check. They take that in a lump sum. And if you're a non-spouse, so a child in this case, you're immediately taxed at ordinary income, which is the highest level you could be taxed. And most people don't know this. So $100,000 turns into $70,000 immediately, and Cullen might not have known. And then he's going to want to buy something, right? The average purchase today for anyone that receives assets, the number one purchase is a brand new car. Cullen has had his eye on Tesla since he was little. Let's call it 50 grand. It's probably more, but I'm just going to lowball it to 50 grand. 70,000, I paid 50 for my car, I'm down to 20. 20,000 in cash. It's no longer in the market. It's not earning anything. Do you think Colin could spend $20,000 in 18 to 24 months? We see it happen all the time. Without communication, without direction, without education with money, it's really easy for your beneficiaries to not know what to do with it. So on the screen here, there's a couple books that I like, depending upon the age. These are really good things, and we can put these in an email afterwards if you don't have the time to write them down. It's kind of a good starter. But again, having that family meeting when your children are old enough to not only discuss your wants and wishes and the specifics, but also talk about the concept of money and being stewards of money really will help this as well. So I'm going to take a pause here, and I'm going to actually put this slide up one more time as I close, and then we'll bring on the group. I don't want you to think about estate planning as having a conversation about death. It's really a conversation about leaving a legacy that's going to affect so many people. You want to have a plan. You want to share that plan. Make sure you're updating it. Be very specific and thoughtful with your planning, and teach that next generation to receive those assets when the time comes. So I'm going to pull my slides down right now, and we'll bring the whole group back on screen.
Emily, that was amazing. And so 30 minutes, you covered so many important and powerful topics. I've got to say that I do this for a living, and I feel like I was standing in front of a fire hydrant for 30 minutes, and so I need to go dry off, right? But I want to just, as we're waiting for a couple of questions to come in, some of the, per se, notes that I took to kind of supplement, not repeat what you're saying, but some things that I have heard it said. I've heard it said that you never really know someone until you share an inheritance with them, right? And so talking about siblings and that sort of thing, I definitely noted most inheritances are completely spent within 18 to 24 months. There's a wonderful book by a CFP named Susan Bradley entitled Sudden Wealth. And it talks about professional athletes, talks about inheritances, and it talks about lottery winnings. And it talks about the fact that money is typically gone in under 24 months. Should be noted, I'm not sure if either of you are aware of what happened in New Jersey yesterday. but there was a single winning ticket to the Powerball lottery. $1.1 billion was sold in the state of New Jersey. So I did call my parents this afternoon. They live in New Jersey, just to ask if there was a need to update their estate plan and my estate plan, right? And unfortunately, or fortunately, the answer was no, they didn't win. Talking a little bit about trusts, and this is something we could spend a whole nother program on, but the idea of trust. So you said a will, a power of attorney, a healthcare directive, and a trust. And people have, I think, a misconception that they don't have a complex estate, or they don't have a big enough estate, and so they just discount even the concept of a trust. But I would say a couple of things. First of all, I want my kids to remember me fondly for a very, very long time. And so you can use a trust to basically sprinkle that money out over time. So if my wife and I have both passed away, depending upon the age of our children, we could make sure that the trust provides for their health, education, maintenance, and support, HEMS, called the HEMS standard. And again, we're not giving legal advice, but that's a common phrase in estate planning. And then the trust could provide income to them during their lifetime, and maybe at certain ages, which when my wife and I, we just are celebrating 35 years of wedded bliss this September. When we first got our wills done when the kids were younger, we had the money distributed at 25, 30, and 35. And when we got to 35, we were like, no way. So we went and got the wills redone. And I think at this point, we're stretching them out all the way to 65 or something, right? But the idea is that I want them to remember me fondly for a long time. And the idea that the trust is paying money out to them at certain ages or certain time intervals or upon certain events. Like, for example, if Mom and I were here, we would likely have made a gift to you when you graduated high school, graduated college, got married, bought your first home, started a business, had a child in wedlock or something like that. Just in terms of these are events that we could describe in our trust document where the trustee could make additional distributions of the trust. So we can be very, very creative in trust planning. And I guess one other thing I would say there is that a trust typically designed, we like to say, to protect from creditors and predators. And so let's just say both of my boys are entrepreneurs. Let's say maybe one of their businesses isn't going well or the economy turns south. And if one of them needs to declare bankruptcy, that money that's in trust is not an asset that the bankruptcy can get to. And that money then becomes what we'll call their start over money, meaning that once they've gone through that unfortunate experience, the money that's in the trust could be used to economically help them to start over. Or in terms of a predator, might be somebody who has ill intent financially and would like, so a lot of times, like when you say you leave the money per se to your boys, you leave it to them outright. If they're married at that point in time, then maybe the marriage isn't going well for whatever reason, and there winds up being a divorce. Well, that money is likely going to be a marital asset subject to property settlement, whereas if money is left in trust for the benefit of your boys, that is not a marital asset and is not subject to property settlement. So there are many reasons that people can use a trust. We love to see trusts in our clients' estate planning. In the world, I think, in which we operate, we look at things largely through a financial lens, and I would say that money is approximately equal to influence. Certainly during our lifetimes, during my lifetime, I'm using the money that I believe the Lord's entrusted to me to influence the attitudes, behaviors, and beliefs of those around me. We paid tuition for private Christian school, or we give charitably to different organizations. And just because I don't wake up tomorrow morning doesn't mean I want that influence to evaporate. And so being able to use a trust enables me to use the financial resources that I've been blessed with to continue to try to have influence even after I have passed away. I appreciated, Emily, that you shared that important documents checklist. I think actually that's what we call it. So you had a document that you put up there. And so we share with our clients when we're doing financial planning for them, we have a secure, encrypted online system that we call the Covenant Wealth Portal, and that includes a fully encrypted vault. And we encourage our clients to engage with that vault. We have what we refer to as an important documents checklist that might include things like your birth certificate or marriage certificate, estate planning documents, and although you need the original will for doing probate when the time comes, having a copy of your will and power of attorney and healthcare directive and trust, having those in your vault makes it easy to see them and to find them. We also like to say here at Covenant that we want to be one of your first 5 phone calls when something happens, whether it's good or bad, because we care and because there's always a financial implication to whatever it is that just happened. And so making Ward or Chris or Randy or Bill or Dan, the advisors here in the office, or anybody on our team, one of your first 5 phone calls, the sooner you bring us in, I think the better off you'll be, because the more flexibility, the more optionality, the more understanding, the more knowledge you're bringing to that circumstance, especially if we're talking about, per se, estate planning. And I appreciate it also that you referenced the trusted contact, because that's something that's relatively new in the industry. And we talk to our clients about, hey, if I can't get a hold of you, I've been trying sending you emails, you don't respond, I'm calling, you don't respond, I'm leaving you voicemails. Something has clearly gone wrong. Who do I call to find out if you're okay? And so that concept of the trusted contact. Emily, you mentioned something also about charity. And a lot of our clients are charitably inclined, and we are very charitably inclined. And so that really resonated with me. And there's a concept out there called the gift of access. And so I wanted to just kind of talk about that for a moment, because you know, when you have maybe a charitable trust or a donor-advised fund, and so let's say I have a donor-advised fund, this is money that's gone in charitably, there are tax advantages, and there's a bit of money in this donor-advised fund, and I unfortunately or unexpectedly pass away, well, what happens to the money in that donor-advised fund? I can name a successor advisor for that donor-advised fund, and maybe I name my sons as the advisors for that donor advised fund. So now they have the responsibility, and depending upon the size of the charitable, principle, if you will. But I mean, even let's just say there's $100,000, quote unquote, left over in a donor advised fund. And let's just say that there's a 4 or 5% distribution rate. That's $4,000 or $5,000 a year that now my sons have the responsibility for giving away charitably. And if they're responsible for giving away thousands of dollars a year or more, depending upon the size of the charitable, trust that's remaining, they will be invited, likely, to sit on some different boards. And when they're invited to sit on different boards, they might meet some people that they might not otherwise meet. And this is what we refer to as the gift of access. So even using that charitable giving strategy as an opportunity to bless future generations and put them in a position to be able to network and meet people that they might not otherwise have met through this concept of the gift of access. 3 other things I'll wrap up with, and then we'll go to questions. So I like what you said, talking about preparing your assets for your heirs is one part of the job. But so often we miss the second and perhaps even more important part of the job, which is preparing your heirs for your assets, right? And so having financial conversations, I mean, again, fortunately or unfortunately, depending upon your perspective, my boys grew up in a house where we talked about financial principles all the time. And so, they have a pretty good understanding of what our thoughts are surrounding money, the things that we value. We've been blessed to be able to make some financial gifts to our kids. And it's neat now that they are in their late 20s and early 30s to see them manifesting. They have their own lives, they have their own per se, things that are important to them in terms of priorities. And it's neat to see them also manifesting some of the values that my wife and I prioritize in their own lives. And I think that we have, per se, begun to already successfully transfer wealth to our children, if that makes sense. So I liked your emphasis on stewardship, and one of the books that you put up there was The Ultimate Gift, and I would just say there's a movie out based on that book. I've read the book and I've watched the movie, and this is one of those instances where I will say that I actually liked the movie much, much better than the book. But it's a powerful and compelling story, and so I would recommend that to you as well in terms of the ultimate gift. So thank you for sharing those resources. In terms of some questions that we had a few questions also come in advance. So Emily, what would you suggest if your parents or loved ones don't want to discuss their estate plans? I mean, especially there's a certain generation, they're very, very private about things. They don't necessarily like to talk about things. If a 50-something-year-old adult child went to their parents who might be of that generation and say, so let's talk, that might not be received well. So what are some tips about how to approach that?
So you definitely know your own loved ones, and it might not be received well. The first thing I say is even a little bit is more than nothing. So they might not want to get into the numbers, which is understandable, but maybe they can give you some locations or some ideas around some topics. So I always say, don't shy back if it's an immediate no. Try to get a little bit. It's more than nothing. But the second is often is if you share your own wants and wishes. The reason I had that family love letter is I have had individuals write it down for themselves, even though they're the ones receiving their parents' assets. And they do so because they've got kids themselves. So they might say, Mom and Dad, if something were to happen to me, you've got grandchildren. I want you to understand what we want. And usually, if you say you've got grandchildren, that opens them up. And all of a sudden, what they were so nervous to say, they tend to divulge theirs as well. So two ideas there. A little bit's more than nothing. And second, just tell them what you want then.
So the family love letter, this is actually something that we've been speaking about internally at Covenant, and this is something that our Covenant Wealth Strategies clients and stakeholders are likely going to be hearing more about over the course of the next 12 to 24 months. We think that this is valuable. We think that it represents an opportunity not only to, per se, convey wealth, specifically in the form of values, but it's also an opportunity to convey some very powerful and impactful words, words of affirmation, words of instruction and direction, per se, to that next generation. I want to even kind of a little variation on that theme. So in our family, one of the things that I really appreciate that we have done is that we have actually done video interviews with the older generations, with the senior generations. And so just one example of that, my wife's grandfather, great man, lots of fun stories. He served on an aircraft carrier in World War II in the Pacific Theater. He was a referee for college football, including the Rose Bowl. So there's all kinds of awesome stories that he could tell, and fun things about his life or amazing things about his life. And so we interviewed him basically on video. We just put a camera up and started recording, and then just talked to him, asked him questions about his life. Where was he born? Where did he grow up? Where did he meet grandma? All these different things. And so it was fascinating to capture that so that we can then share that with future generations. And at the end of the video interview, my wife said to him, "Granddad, I want you to look into the camera, and I want you to speak to future generations that have not yet even been born and will likely never know you personally. What words of wisdom would you like to share with them?" Right? So this is kind of a variation on the theme of a love letter to be included with your estate planning document. So just wanted to share that. Another question that had come in, Emily, is can you have more than one power of attorney? So maybe talk a little bit about the idea of a durable power of attorney versus a limited power of attorney, and that might be helpful.
Yep. So the answer is yes, you can name more than one. I always say it may make sense to do it more of a primary and then a secondary. And the reason for that is if you have two names, they equally have to decide. So again, going to the concept of creating family infighting, equally deciding on something really difficult with mom's health might cause controversy. Or equally deciding on something to do with mom or dad's money might cause controversy. So the answer, yes, you may put two names down, but I find it makes a lot more sense to do one over the other, like a backup, than having two equal.
Yeah, and you're talking about having two individuals named within the same document, right? And maybe that's what the question was. I was thinking about, like, if I had a limited power of attorney for a specific instance or event, like buying or selling a home, that's different than a power of attorney. So maybe I misinterpreted the question. So yeah, that brings up actually a really valid point, though, because a lot of times, let's just say mom and dad have two kids and they want to be quote unquote fair or whatever, so they name both of them jointly, right? So
Yep.
that happens frequently.
Yep.
And back under the heading, you never really know someone until you share an inheritance with them. You know, they might have differing, and not even just with the financial power of attorney, but with the healthcare directive, which is sometimes called a medical power of attorney. You know, one of the children, per se siblings, you know, basically thinks mom lived a good life and is suffering and thinks that we should pull the plug. And the other child says, how could you do that to mom, right? And so, you know, we see these things as well. So it might be helpful to name, per se, an heir, a child with a medical background as your medical power of attorney, and name an heir who generally has good organizational or administrative skills, or maybe even a financial background, as your financial power of attorney. So do you see that in conversation with people?
Yeah, that's actually how my own family's set up. My sister is in the elder care space, so she is naturally my parents' medical, and I am the financial space, so I am financial.
There you go. Great. Okay. So here's a question, and actually this is a question that came in, and I want to actually expand on it because I think there's another fascinating aspect to this. What happens if you are named executor in somebody's will, okay, but you don't live in the same state as your loved one or, say, parents who passed away? I'm going to ask you to answer that question, and I'm going to ask a follow-on question or give an example of something that I've seen also.
Sure. So going back to estate law is a state-by-state basis. So you will physically have to go to the state where the person is a resident of that past and go through that court system. And it might not just be one trip, there might be multiple trips, and it might cost money, and it's certainly going to cost time. So I'm always careful when I tell people, you usually want to name your most responsible person that role. Ask them if they want to be it, because it does take quite a bit of work.
So that's exactly where I was going to go with my follow-up question, both in terms of naming someone to be your executor, naming somebody to be your power of attorney or healthcare directive, and especially naming somebody to be guardians of your minor children. It blows my mind, but you would be amazed how many times we encounter people who have done their estate planning documents, and for that we give a round of applause and give them kudos, but they never asked the people that they named in those different roles. And I mean, that just blows. I mean, I think about, so let's just say my next door neighbor has two kids, and their kids are younger than ours, are now 31 and 28, I guess. And so our kids are out of the house, but our neighbors named us as guardians for their minor children. I mean, we're grandparents at this point, And we get to sugar them up and send them home, but now our neighbors pass away and we wind up with a 7-year-old and a 5-year-old back in our house kind of thing. So you mentioned in passing, but I think we really want to make sure that the point is driven home. You need to ask the people before you name them to roles in your documents. All right, I guess I covered that one. I think I mentioned this earlier, but Emily, if you have some additional insight that you'd like to share, what if you have a donor-advised fund or some type of a charitable fund, what happens when you pass away?
Yep, you actually answered that, and I'm glad that you did because you brought in the gifted access. And I remember you telling me that in our meeting prep, and I love the concept that you name someone just like any other document to be the next in line to carry out that donor advised asset, and giving them essentially not only a way to carry on your legacy, but possibly getting them access to others that, can help them along the way too.
Awesome. One of the questions that came in, I think you addressed this during your presentation, but the idea of estate laws, specifically, they vary state to state. And so would my documents still hold up if I did, for example, you said you did your documents in Virginia and then you moved to Maine. So first of all, you said, hey, you should update your documents or you should at least have them reviewed. But what happens if you don't? Do my documents from Virginia still hold up in the state of Maine?
So the legal documents created, long as it's created, not somebody just scratching something out, they will hold up. But what it might do is it might take more time. So it might slow down your process and it might cost more money to make any last changes that are needed. But yes, it will hold up. You're not going to have a disaster happen. But I do think it makes it a lot easier for your heirs if you've got everything to the right state regulations.
Best practices, make sure your stuff's up to date. I've heard it said that everyone leaves a legacy, and the question is not whether or not you will leave a legacy, the question is what kind of legacy will you leave? So last time I checked, the chances of passing are still 100%, and so it makes sense to have these documents in place. You can put these documents in place. We say that once your documents are finished, good job, you're halfway done. You have to come back and do your beneficiaries, update your beneficiaries and your asset titling. But you can leave a legacy of organization and communication, or you can leave an absolutely unmitigated disaster. We have seen both, and it is heartbreaking to see the people who go through the latter format for sure. Well, Brian and Emily, we are so glad to have you with us today. Thank you so much for sharing from your wealth of knowledge. Are there any closing comments that you'd like to share with us, or any topics that you would leave out there for us to say, hey, let's follow up on this next time?
My closing comment is October is estate planning month. So I challenge everybody on this webinar to have all of their documents set and done by then, along with all of their family members to do the same. Estate
planning month. For those who don't know, I get made fun of because I have more letters after my name than in my name with all the professional designations. One of those sets of letters is AEP, which stands for Accredited Estate Planner. And in fact, I was on the Estate Planning Council of Delaware Board of Trustees for a number of years. So we have some knowledge in this area. Please feel free to tap in and leverage the knowledge and experience that we have. We are not attorneys. None of us on this Zoom call are attorneys. We do not give legal advice. We do have extensive knowledge, and we can help to work collaboratively with your estate planning attorney so that you get the best possible outcome that accomplishes your objectives. So we thank you, Emily. Brian, thank you for bringing Emily to us. We appreciate the relationship that we have with MFS. And should you have questions about your own individual circumstance or like to discuss this further, you can tell we have a little bit of enthusiasm and passion around this particular topic, so we would be more than happy to field your phone call, have a meeting, a Zoom call, whatever your pleasure is, and discuss how we can help you get started transferring wealth to future generations. Thanks so much for joining us today.